essay on the perspectives of legal education, written by Dr. Ganga Sahai Sharma sir. A need has been felt for a long time to overhaul the system of legal education in India and to reorient it in the light of the changed socio-economic context. But little effort has so far been made in this direction. The present system of legal education in India is what the British people created when the law was recognized as the weapon of social order rather than an important instrument of social change. The task of judicial authorities, lawyers, and the law teachers was naturally unconcerned with the policy formulation. In this context, the function of the law colleges was only to impart information regarding the rules of law in certain basic subjects, irrespective of their social significance, purpose, or policy. With the achievement of independence on 15th August 1947 and the commencement of the new constitution on 26 January 1950, the system of legal education became incapable of playing any useful role in the changed set of circumstances. The social objective enshrined in the Constitution is the establishment of a welfare state based on socialistic pattern. Therefore, it is now the responsibility of the legal education to produce lawyers who will be able to minimize the friction in the process of social change. In essence, a training in scientific thinking will have to be imparted to the law students who are to take law as a means of planned implementation of policy. Hence, the study of subjects like history, economics, sociology, political science, etc. should be included in the sum of law courses, either simultaneously with the law subjects or separately by devoting a year or so. A combination of the study of law and other social sciences is bound to make him a successful lawyer. There are two predominant methods of law teaching. The first method of law teaching is the case method and is employed in the United States. The other method of law teaching is the famous lecture method operating in England and many other countries. Both these methods have produced fruitful results in the respective countries. Their suitability in Indian situation, however, deserves some consideration. In the case method of teaching, the teacher does not explain the principles of law or various legal concepts. The students express their views. In the lecture method of teaching, usually the teacher does not put questions to the students. The teacher delivers the lecture on a specific subject and the students accept each word as it comes from his tongue. Thus, there is no student participation in this process. We have some basic problems which do not permit us to import case method of teaching in our system of legal education. We do not have trained personnel and legal literature, which are prerequisites for the introduction of case method of teaching. Therefore, in the present situation, lecture method may continue for imparting legal education in India. However, it is suggested that lecture method be supplemented by a properly drawn up scheme of tutorials and seminars. The main purpose of tutorials is to provide individualized attention to the students. In tutorial, a teacher aims at removing the difficulties of the students, that means to guide him where to find law on a given subject. The purpose of holding seminars is to develop the critical faculty of the students through discussions. The law schools in India should organize weekly seminars of 1 hour duration in every subject. A few students should be asked to prepare the subject from both the angles. The teachers should control and guide the discussions, help students to build up arguments, point out the weaknesses of some uncalled for discussions, tell the students the socio-economic consequences which would come out of the discussions. Clinical legal education has become very popular institutions throughout the world very recently. In clinical legal education, there is an involvement of the students. In some places, there is such tradition for free legal aid to poor. Clinical legal education is a term which denotes the involvement of students in the representation of actual clients as part of the legal education. Thus, the term denotes students' legal clinics and traditional apprenticeship. The holding of moot courts, courses in trial of cases, and courses in legal drafting are to be covered within the term clinical legal education. The services of the students and law teachers who are associated with the clinical legal education can be utilized for the purpose of legal aid to the poor, a concept which has emerged and inserted in Article 39A of our Constitution. It is high time when the authorities should take steps to attach students' legal service clinics with the departments of all the universities, government as well as private colleges on the lines suggested above. Only a legal education which includes court visits, practice of legal aid clinics, detailed discussion of brief and compulsory participation in moot courts would better prepare the law students for the demands made in the court. We can therefore conclude that if all of us realize the significance of the function of law in a democratic state, we would recognize our obligation to the society at large, because service of law on the ultimate analysis is a service of society itself. Thank you.